80. Okay, so they're in. Oh, okay. All right. The audio's on. Okay, well, it's 9 o'clock. Let's see if we can get him here. Okay, good morning, everybody. Let's go on the record in 2023-01783. And Mr. Brown, are you there? This is Judge Cooper.
Good morning, Your Honor. I am here. This is Nathan Brown for the plaintiff.
Okay, very good. Thank you. And then in the courtroom.
Good morning, Your Honor. Larry Cohen for defendants Johnson and Scovel.
Very good. Thank you. All right. So we're here for oral argument on the pending discovery-related motions. The court has read the motions, and of course the responses and replies. I've made some notes. I think I understand this, kind of the scope of the issues. I am interested, though, in hearing what you all want to emphasize to me or with respect to those motions this morning. I'm happy to start in any order. I thought we'd start with the two that seem to be related on the issue of the attorney-client privilege, the video and the statements.
Yes, Your Honor. If it would be all right, could we take those one at a time? Because I'd like to address the video first and then the attorney-client.
Absolutely.
Thank
Absolutely. And, my thought was, just in the interest of time, I don't know, we have plenty of time this morning. I'm not worried about that. But I don't know, why don't we just kind of take them one at a time and we'll go from there.
Thank you very much,
Okay.
Your Honor. I assume does Your Honor want me to take one, then you'll do the response or reply, and then the next one? Should we proceed that way?
Let's do that, and I'll just keep an eye on the clock.
Thank you, Your Honor.
All right.
The first motion to talk about, Your Honor, is the video motion. It may be referred to as a Blue Jeans video, but I'm going to refer to it as a video.
All right.
And also, Your Honor, there'll be references to what I'll call the underlying proceeding, which is CV 2020-010-557. I'll refer to that as the 557 litigation and on this and all the other motions. So just to make it easy to refer to that.
Okay. I will tell you, just to be honest, I didn't go back and read through that docket. So if you could give me a little context in terms of how all of this came about.
I'm happy to, Your Honor. The underlying case is a matter that was brought by a number of parties. My clients, Ms. Johnson, Ms. Wilson Scovel, I'll refer to her as Ms. Scovel, were plaintiff parties in that case. The case involved a defamation action. It involved a dispute among a number of members of a homeowners association, the Vista Lakes Homeowners Association. And the issues presented, Your Honor, sort of grow out of that case. That case has been resolved in the sense that there were rulings by the court. There were parties who were dismissed. There were judgments that were entered. There were judgments that were paid or settled, and that case has been resolved. This case arises out of that, alleging that the circumstances of that case involved malicious prosecution.
Okay.
And so what's being attempted here, and the focus of the motions, is an attempt to use attorney-client communications between my clients in that case and their attorneys in that case, the 557 litigation, their attorneys being the Jardine, Baker, Hickman, and Houston law firm. The focus of the motions as I filed them is to address efforts to use attorney-client privilege communications between the clients and the attorney in connection with the matters that are the subject of this case. And the overall point that I'm going to be making, generally and specifically with regard to the video, is that at no time did the clients expressly waive privilege, and at no time has privilege been impliedly waived. And I'll focus on why that's the case as I go forward. And the goal today that I'm seeking, just to sort of anticipate the endpoint that I'll be asking you to, the request that I'll be making, is that you rule that for purposes of the pretrial litigation, to include deposition practice, discovery, and motion practice, that the attorney-client privilege remains in place and is not something that can be inquired into or used in the course of discovery practice or motion practice, but rather remains in effect. The plaintiff's position is that attorney-client privilege has been waived all over the place, and they can go into that, but the purpose of these rulings is to address that issue. I'm not asking Your Honor to rule today as to trial matters because I don't know what's going to happen generally in the course of the litigation, but I want us to start out for where we are now. My goal is for us to start out for where we are now with attorney-client in place. So that's sort of the bigger picture. There's a discovery master issue out there that relates to this, but for right now, I'm going to stay focused on the video motion first and the attorney-client motion second, okay? So, the video motion involves something called the Blue Jeans video. And the reason it's called the Blue Jeans video is that happens to be the technology that was being used to create it. And what occurred to create this video was a telephone conference, a video telephone conference, in which the attorneys, two of the attorneys representing the parties in the 557 litigation, and had a conference in which they talked about the case, what they were trying to accomplish, strategy, goals, and things like that. It lasted about an hour. The video was created because one of the attorneys in particular, an attorney by the name of Mike Wierzinski, wanted to have the information that he would be getting through this conversation available to him to refer back to as the case went along. So the only people in attendance for that video were Mr. Wierzinski and Mr. Jardine, attorneys, and two clients, Ms. Johnson, who's a defendant party in this case, and Ms. McCoy, who was a defendant party in another malicious prosecution case, which has since been dismissed. Ms. Scovel did not attend, but is referenced in there. And in the video, there was a comment made about Ms. Scovel having the opportunity to look at the video at some time if she wanted to, though she never did. The references that were in my filings to the 557 litigation were filings in that case that addressed the video and what was to be done with it. And I'll refer back to that as I go through. But that's the big picture of where we are and why I made reference to those filings in the course of my my written brief on the video and the attorney-client issues. Now, again, part of the big picture, that video was never intended to go anywhere. No copies were ever made of it. In fact, the clients never got copies of it, and they never even watched it. It was put into a Dropbox from which the attorney who wanted to use it, Mr. Wierzinski, was going to draw on the video to do his work representing the clients. What happened, and I'll get into more detail about this a little bit down the road, what happened is that at some point they reached a time when a omnibus disclosure was going to be done, or a discovery response was going to be done to like 5, 6, or 7 discovery requests. And so a staff person at the firm compiled all the information into written documents and also created a link to a Dropbox and sent the documents and the link out to everybody. And by everybody, I want to be very clear who everybody is, because it becomes a big issue in this case. Everybody were the attorneys or the law firms that had been involved in that litigation, either were presently involved or had been involved and were some transitional phase, but in any event, were still involved. It was not to send to anybody outside the law firms. There's a large number of references because attorneys these days have a way of saying, well, don't just write to me, write to these other 7 people in the firm, copy them as well. You know, my paralegal, my secretary, this other attorney working on it. So you get a proliferation of emails, but they all go to the same firm. So there's a large number of email, but they all went to the law firms, and they're all firms that were either at that time involved or had been involved in the case. So what happens is that the staff person links a Dropbox that has the video in it inadvertently. was never intended to be disclosed to anybody, but she inadvertently discloses it. And I'll talk in detail about what happened with that in a minute. I want to cover a few rules first, but the evidence, and since you haven't looked at the 557 file, I'm going to hand you some documents that I referenced in my materials, so you'll see what I'm referring to. But the evidence is very clear that it was inadvertent in the sense that she had no idea it was in there. They found out about it when one of the attorneys who received it said, "Hey, this is a privileged document. Did you mean for us to get it?" And then immediately steps were taken to say this was an inadvertent disclosure, destroy it. And again, I'll come back and provide more detail on that. I want to spend a minute or two, though, Your Honor, talking about the applicable rules. They apply to this motion, and they apply to the attorney's fees motion in particular. Or this motion in particular, and the attorney's fees motion. I want to cover both of them. The principal rule of importance here, though other rules are very, very important as well, but the principal rule of importance is Rule 502 of the Arizona Rules of Evidence, and most particularly Rule 502B. It's important, A, for what it says, and B, because it casts its effect across litigation. In other words, it's not bound to just what went on in the 557 case. It applies as a rule of evidence to all cases, which would include this case. So, Arizona 502B of the Arizona Rules of Evidence specifically deals with circumstances when there's been an inadvertent disclosure. And what it says is that when in an Arizona proceeding, the disclosure doesn't, it said when made in Arizona disclosure proceeding, the disclosure, and again, the category is inadvertent disclosure, the disclosure does not operate as a waiver in an Arizona proceeding if the disclosure was inadvertent, the holder of their privilege or protection took reasonable steps to prevent disclosure, and the holder properly took reasonable steps to rectify the error, including following Arizona Rule of Civil Procedure 26B6B. So we then turn to the other rules that apply. And before we get to Rule 26B6B, Rule 26.1 comes into play in the sense that it says that when there's been an inadvertent production, which is what happened here, if a party contends that a document or electronically stored information subject to a claim of privilege or protection as work product material has been inadvertently disclosed, the producing and receiving parties must comply with 26B6B. So 502 points us to 26B6B and 26.1 points us there. So then we get to 26B6B. I won't read the entire motion. I know Your Honor is familiar with the rules of procedure, but I do want to focus on the parts of it that are particularly relevant here. What the rule says that if a party contends that a document or electronically stored information subject to a claim of privilege or of protection as work product material has been inadvertently produced, and Your Honor is going to see the evidence that they claim that it was privileged and inadvertently produced in discovery, the party making the claim may notify any party who received the document or electronically stored information of the claim and the basis for it. That was done. And then it says, after being notified, a party, referring to whoever receives it, under Section 2, which is the part I want to focus on, though that all the rules apply, it says a party must not use or disclose the document or electronically stored information, and this is key, Your Honor, until the claim is resolved, referring to the claim of privilege. And I will tell you, to foreshadow everything, that claim has never been resolved. In other words, the claim of privilege that was made has not been ruled upon by a court. In other words, no court has come in, looked at all this and said, oh, well, that document is privileged. It hasn't said it hasn't been privileged. The point is it hasn't been resolved, meaning that we are in the position contemplated by the rule where the inadvertently produced document about which notification was given, the rule says that after being notified, and I'm going to show you that Mr. Brown was notified, must not use or disclose the document or electronically stored information until the claim is resolved, and it's not been resolved. And so between Rule 502 and Rule 26B4B, we're in a situation where that privilege is still sitting there. You're going to hear, and I'll get into this later, about how this document has been exposed to 5,000 people, and you can get on the internet and type in Blue Jeans video, and it'll show up, and the whole world knows about it, and they're talking about TV shows and everything else. They can do all of that, but for purposes of the rules of evidence, which govern the proceedings in this case, and the rules of procedure with how you deal with an inadvertently disclosed document, that document remains privileged. There's been no ruling otherwise. So those are the rules that are particularly important. I'll talk about a number of cases, but let me go in now and give Your Honor the factual background. So I've given you the background about how it came into being. There is a declaration in those materials, Your Honor, that I referred to, in which Mr. Warzinski, at the very beginning, says, we're doing this so I can have it available. And at the very beginning of the video, within seconds, says, now, let me stop us for a minute before we go anywhere. This is a privileged communication. So you only have to listen to a few seconds, maybe a few exaggeration, maybe 10 or 15 seconds of this, and you immediately come to Mr. Warzinski saying it's privileged. And you don't have to rely on me to tell you that, Your Honor. You're going to see it in one of the email messages I'm going to show you in a minute. So on August 5th at about 5:20 p.m., the disclosure or the production of discovery materials went out. And as I said, it included a number of items, Your Honor. Let me show you if I could. And Mr. Brown has this, so I'm not showing you something that's not in the materials that he has. May I approach, Your Honor?
Oh, you may. Thank you.
If you look at this document, Your Honor, you'll see it was sent out by a C. Sejkowski, who's a staff person at the JBAH law firm. As you can see, it was sent on 8/5 at 5:20 p.m. And you see a list of the materials that are there. The responses to various matters, and then a reference to a Dropbox links. Okay? It's important for Your Honor to note, this is not the full list of everyone it was sent to. For whatever reason, on the copy I got, the list of recipients is limited, but one name is on there. On the second line, or the third line down, it's Nathan.Brown at brownpatentlaw.com. He got the disclosure, he got the link. I'll foreshadow you and tell you, Your Honor, he's never acknowledged that. And he's never acknowledged receiving the inadvertently disclosed material, but he's on that email, and you're going to see him on all the others. So at least by virtue of the documentation that we have, he received this. Now, that's August 5th. We next come, Your Honor, to August 10th. May I approach again, Your Honor?
Okay. Yeah.
On August 10th, Elizabeth Fleming, who's one of the attorneys in the case and was an addressee to whom this was sent, Ms. Fleming sends a message to everybody. Now, I'm going to ask Your Honor to take a moment and look in the to section. If you go down to the third line, you will see that she sent this to a number of people, including Nathan.Brown at brownpatentlaw.com. And what she says is, Mike, Brad, and Chris, in the discovery responses you sent out, there is a video called McCoy Blue Jeans Call, October 16, 2020. I watched this for a few seconds, and then Mike raised the issue of privilege over the discussion, so I immediately stopped. Before I resume, can you please advise if you meant to disclose this or if I should destroy it? So that's their first notice, that this thing has gone out inadvertently. And again, it's sent to everybody, including Mr. Brown. I get back in a minute to the question of who Mr. Brown is representing at that time, because he's taken the position in one of his filings that Shirley Schmidt was not the plaintiff here was not someone who was involved in litigation at that point. That's not true, and I'll show you why, but I'll come back to that later. The next thing that happened, Your Honor. May I approach, Your Honor?
Yeah.
The next email.
Thank you.
The next email, Your Honor, is from Deanne Willis, who is another member of the staff at the Jardine Baker Hickman and Houston firm, at 9:13 in the morning. So again, just notice the timing, if you would please, Your Honor. Ms. Fleming's message goes out on August 10 at 4:28 p.m., essentially the end of the day. The next morning, Ms. Willis sends out her email the next morning at 9:13 a.m., at the beginning of the day. And she says, Ms. Fleming, thank you for bringing this to our attention. Apparently the wrong link was inadvertently sent with the disclosure responses. Please delete all documents and video other than the folder name PLS on the RFP response. Sorry for the confusion. I'm going to ask Your Honor to again look at the 2 line in this, and you'll see 3 lines down is Nathan.Brown at brownpatentlaw.com. He got this.